How were the Geneva Conventions and Rome Statute drafted? Have you ever wondered how the rules of war came to be? The Geneva Conventions and the Rome Statute are key documents that shape international humanitarian law. Let's take a closer look at how these important treaties were created. The Geneva Conventions were drafted through a series of international discussions that began long before the final agreements in 1949. The first Geneva Convention was established in 1864, inspired by the experiences of Henry Dunant, who witnessed the suffering of wounded soldiers. After World War II, there was a strong push to update these rules to better protect individuals during armed conflict. Starting in 1947, multiple international conferences took place, bringing together government experts, representatives from the International Committee of the Red Cross, and various states. They discussed how to improve protections for wounded soldiers, prisoners of war, and civilians. The final conference in Geneva in August 1949 resulted in four treaties, which we now know as the 1949 Geneva Conventions. These treaties set forth protections for those affected by war, including civilians. The drafting process was not simple. It involved balancing the need to limit violence in war with the military interests of states. Delegates negotiated what types of violence would be prohibited and what would be allowed. This resulted in extensive documentation that continues to guide the interpretation of the conventions today. On the other hand, the Rome Statute, which created the International Criminal Court, was drafted much later, beginning in the 1990s. Unlike the Geneva Conventions, which focus on humanitarian protections, the Rome Statute defines specific international crimes such as war crimes, crimes against humanity, and genocide. It also established a permanent court to prosecute these serious offenses. The drafting of the Rome Statute involved diplomatic negotiations among states at the United Nations, expert meetings, and consultations with legal scholars and civil society. After much discussion, the Rome Statute was adopted in 1990, during a diplomatic conference in Rome. This document reflects a global agreement on holding individuals accountable for serious violations of international humanitarian law and human rights during conflicts. Both the Geneva Conventions and the Rome Statute aim to protect civilians and combatants from abuses during war, but they approach enforcement differently. The Geneva Conventions set standards for conduct during conflict, while the Rome Statute provides mechanisms for legal accountability for breaches of those standards. In practical terms, the Geneva Conventions form the foundation of the laws of armed conflict, guiding how hostilities should be conducted and how individuals should be treated. The Rome Statute strengthens enforcement by allowing for the prosecution of war crimes and other serious breaches. Together, these documents play a vital role in defining legal norms and ensuring consequences for violations, ultimately contributing to the protection of individuals during armed conflict.